We'll hear from the government.
Thank you, Your Honor. May it please the Court, Daniel Tenney for the United States. I want to start on the deposit copy issue, and I think it's helpful just to sort of walk through the various versions and what protection they received at various times. When a deposit copy was presented to the Copyright Office, that was a deposit of a complete copy of the copyrighted work. That's what the statute says. And so the composition embodied in that page of sheet music obtained federal protection on the date that it was submitted to the Copyright Office. There may have been a more complete version of the song, and the statute and the compendium, both then and now, refer to the possibility that there will be more than one version of a work, and they might be separately registrable or entitled to copyright protection. If there was a more complete version that included protectable elements that were not in the deposited version, then any common law rights that existed in those protectable elements would have remained. The federal copyright wouldn't extinguish those. Then in 1978, works that were not that had not been published and had not obtained copyright protection under what is now 303A of the Copyright Act obtained federal protection, and so any protectable works any protectable elements of a work that had not previously obtained copyright protection would then be protected by federal law, but you would need to separately register that work, whatever it was, and at that time, as was pointed out earlier, you could register by using a sound recording for registration, and you could say, insofar as a composition that contains protectable elements that I didn't receive copyright protection for before is, you would present that and you would say, I want copyright protection for that. And you would get it automatically. The protection would happen automatically under the statute, but in order to file a lawsuit based on it, you would have to register it with the Copyright Office. This is assuming that you hadn't lost the protection in some other way, that it hadn't entered the public domain. And so, but all we're dealing with here in this case is, because none of that was done, there was no sound recording deposited. It's clear that you couldn't deposit a sound recording before 1978. That was in the regulations. It's clear that copyright owners were told, based on the compendium, which we've included in the appendix to our brief, they were told that all you're getting protection for is what you deposit for us. If there's an element that you think is important in your composition that's not in the deposit copy, please submit a new copy.
Can I ask, do you happen to know, is the point that you've just made here, post-enactment of the 1976 Act, is that why we really don't have any case law that deals with this, what happens under the 1909 Act? Because it seems like, I don't know, we've spent, the better part of an hour debating this point about the deposit copy, and it just seems like maybe it's completely irrelevant for all but a tiny portion of cases out there, this being one of them.
I think that might be one reason, Your Honor, and there were musicians and studios that after 1978, the effective date of the 76 Act, that deposited, copies of their sound recordings to say, we want the composition reflected in this sound recording. So that it could be one reason. I think there are other reasons that, most copyright claims are about melodies and lyrics, and those are the sorts of things that people put in their deposit copies anyway. And so, that sort of segues somewhat to the second issue in the case about whether there was infringement here. But it's true that this is not a circumstance in which it's impossible to get protection. It's just that the mechanisms that were used weren't done here for one reason or another. At the time that the song was, that Stairway to Heaven was written, to the extent that there are common law rights, we haven't taken a position on whether that's true or not, but if there were common law rights, they could have sued on them right then. And then subsequently, after the 76 Act took effect, they could have deposited a recording and said, we want protection for the composition embodied in this recording, and then they could have brought an infringement suit based on that work. But the work that they brought this infringement suit based on was the deposit copy, the sheet music, and which is a complete copy of the work that they obtained federal copyright protection for. So in order to prevail, they would need to demonstrate that there was infringement of that work.
Can I ask you a question about your thin versus broad protection, which is, I think, the issue posed in your amicus brief? You suggest in your brief that when we're dealing with, let me call them selection and arrangement of uncopyrighted elements, it always gets thin protection when we're dealing with music. Isn't that your position?
Your Honor, I think there are some caveats to that would limit that.
Tell me what the caveats are, because
as you say,
that broad proposition troubles me.
Because what we've talked about is when you have a small number of conventional elements. So here what we're talking about is two elements. We're talking about a descending chromatic scale and a chord, and maybe you would count three if you count the broken chord as separate from the chord itself. But in any event, it's a small number of elements. These are conventional musical elements. The test is we're not trying to set any broad rule for music that's different from the rules for anything else. The question is whether, if the range of protectable expression arranging these particular elements is small, and this is what has come up in a number of other contexts, then protection is thin.
And that's the basic law on the topic. That's what Rentmeester says. That's what our fabric case says. But I thought you were arguing for a broader proposition, and maybe I was wrong, that when we deal with music and uncopyrighted elements, that they always get thin protection in selection and arrangement cases. That's not your position.
I hope that we were, and if we weren't, I'll be careful today to talk. We're talking about a small number of elements.
Take yourself out of the facts of this case for a second. I'm asking you a legal question. Is it your position that when we deal with selection and arrangement of uncopyrighted elements, uncopyrightable elements in a music case, they always get thin protection, or do we apply the general test that Mattel and Rentmeester talk about?
No, we're not going that far, Your Honor. And we're not saying, what we're saying is when you have a small number of conventional elements and where the number of,
Excuse me, the government in its brief seemed to rely mostly on Satava, which was the jellyfish in a glass case, and the Apple case, which was the screen of the Apple computer, what a desktop looks like. What cases, is there a robust line of cases indicating that music with a few number of elements gets thin protection? Because it seemed like music was treated more like books, and even though the same words are used in book after book, and even the same types of phraseology, it does not get thin protection in that way. What's the list of Ninth Circuit cases saying that music gets thin protection?
There aren't a lot of music cases either way, and I think this goes back to the point I made earlier that most music cases are about melodies and lyrics and circumstances where everyone would agree the protection is broad. And Williams versus Gay, which was alluded to earlier, there were a lot of elements there. There was a melody. We weren't talking about a small number. Selection or arrangement of a small number of basic conventional musical elements. So I'm not sure that the issue is...
We would be breaking new ground to apply this thin protection concept to musical compositions. Is that right?
Well, potentially, but I think it would be further breaking new ground to say that it doesn't apply in music when it has not been context specific in the past. So it's been applied to artworks, it's been applied to musical interfaces. This court talked about how it was applied decades ago in the context of a play and characters in a play. This is just a general concept, and the application...
So the bottom line is the government is taking the position that selection and arrangement and thin copyright, as has been known in the pictorial, graphic, and sculptural works, should be applied in the same way in music works. Is that correct?
Right. Obviously you'll have to, adjust for the context in order to figure out what are conventional elements and how broad the range of the range of expressive possibilities are. But here, to say I'm combining a descending chromatic scale and an A minor chord, there are a very limited number of ways to do that. So it fits within the framework that was set out in those other cases, in those other contexts. And so you would say, just as there were a small number of ways to put a jellyfish in a jar, or a small number of ways to make the graphic interface under the constraints that were placed in that case, you would say here, there are a small number of ways to do this. And so maybe if you think that this arises to the level of being copyrightable at all, At most, it would receive thin copyright protection, so we would want to look to whether the works are virtually identical. And since these works, nobody is saying are virtually identical, and you can tell by looking at the notes and the rhythm, that's why we thought at the end of the day that the defendant should prevail in this case.
If I could just follow up on this line of questioning, because it looks like one of the amicus briefs argues that our court's opinion in Swirsky versus Carey, they argue stands out in allowing the plaintiff to proceed with the selection and arrangement claim with broad copyright scope. Do you agree?
Your Honor, if I could, my time has expired. If I could
Please
answer the
answer,
question. I think what was at issue in that case was a short melody, and that's different from a selection and arrangement of basic elements. So I don't know that I agree with the characterization of that case. What we're talking about here is a baseline that's composed of a chord and a descending chromatic scale. I don't think that's similar to what was at issue in Swirsky, so I don't know that.
He said a title hook phrase, the shifted cadence, the instrumental figures, the verse chorus relationship, and the fade ending. Are we to say that that's just melody? I guess I'm not that educated in musical terminology to know.
I guess the title hook phrase, the hook is supposed to be, if I understand the terminology correctly, sort of the catchphrase, the thing that keeps your ear, and so I don't think we have something like that here. The case certainly doesn't stand for the proposition that you could debate about whether it was true or not that was a combination of a small number of conventional elements. The case certainly doesn't stand for the proposition that even if you have a combination of a small number of conventional elements, you don't get thin protection. It doesn't say anything like that. And in this case, it seems clear that that's what we're talking about here, again, if we're limited to the deposit copy, and so then under applying the same framework that's applied to other copyright cases. I've gone over my time. I appreciate that.
Thank you,
Your
counsel.
Honor.